Good evening, everyone. Thank you for joining us. This is WiCCD's first update on the recent appellate decisions in Canada. We're very happy to see you tonight, and we're very happy to have a wonderful panel and our lovely moderators tonight, Jennifer Penman and Shira Brass. I won't be talking for too long. I just wanted to let you know that this session is eligible for 1.5 hours or 1 hour and 30 minutes of substantive CPD, and that's for Ontario. I'm not too sure about other provinces, but this is a CPD eligible program, and we will encourage you all to stay with us until the very end because we do have one lucky winner who will be winning book from Emond Publishing, and it will be on sentencing. So stay with us until the end, and I hope you enjoy this session. And Jennifer and Shira, it's up to you.
Thank you, Maya. Thank you again, as always, for organizing such a great event. You're amazing. Hi, everyone. My name is Jennifer Penman. I'm a defense counsel from Toronto, and myself and Shira Brass, who's also on the Zoom screen, you can see us both, are co-moderating this event. So as you can see, obviously, this is a case where we're talking about recent appellate decisions. We thought we would do kind of program really more from an education standpoint. What do we need to know about these cases and their practical implications? You should have all received some kind of link with the cases attached so you can look at them. And the idea really is to have access to these cases and know what to do with them when you're in a court, because they can be really helpful. So we hope you enjoy and learn from the variety of cases that we're going to be discussing tonight. So I now want to introduce you to two of our panelists. The first panelist that I'm going to be talking about is Christa Thompson, and she is a lawyer from Nova Scotia who has focused her career on criminal law and social justice advocacy. She recently worked as a full-time staff lawyer with Nova Scotia Legal Aid, representing youth and low-income Nova Scotians. And then last summer, she decided to switch things up and moved on to Hutchison Law, where she works remotely from her home office in beautiful Cape Breton. That just sounds lovely. She continues to act as a vice president of the Nova Scotia Criminal Lawyers Association, and her passion areas are youth justice, advocating for Indigenous clients, and promoting cultural competence within the justice system. Our other amazing speaker is Kyla Lee, who is a prominent criminal defense lawyer and impaired driving lawyer from Vancouver, BC. She's appeared in all levels of court in BC and at the Supreme Court of Canada. Her main practice areas are criminal defense, administrative law, driving law, and drug charges. She is an expert in defending drinking and driving cases, and known in the legal community as the IRP lawyer, having tons of expertise and being the author of the textbook on defending 90-day immediate roadside prohibition, drive under the influence type cases. She is Métis and maintains her interest in Native issues and developments in Aboriginal law. Christa is going to be speaking about the super important cases of Morris and Anderson, and the more recent case of King dealing with Gladue and the Corbett principles. And Kyla is going to be speaking about her niche area of the case of Boyle, dealing with driving prohibition and criminal negligence causing death cases. And the case of Major, dealing with issues around the admissibility of EDR, event data recorder evidence. These are areas that I don't know a ton about, so I'm super excited to just listen and learn. Shira, over to you.
Yes, the other speakers we will be hearing from are Stephanie DiGiuseppe and Sara Little. I'll first be introducing Stephanie. Stephanie is a partner at Ruby Schiller and Nenajor and DiGiuseppe Barristers, where she practices criminal, constitutional, and regulatory litigation. She has represented clients before all levels of court in Ontario, administrative tribunals, professional regulatory bodies, and the Supreme Court of Canada. She acts as counsel with pro bono inmate assistance at the Ontario Court of Appeal. Stephanie is an instructor at Osgoode Hall Law School, where she teaches criminal law and also teaches trial and appellate advocacy skills to practitioners. She is the co-editor of the Constitutional Rights Reporter. Stephanie is an active leader in Canada's legal community and a dedicated advocate for social justice and legal systems change. She sits on the board of directors for the Criminal Lawyers Association Peace Builders Canada, and Cannabis Amnesty. Stephanie will be speaking about the cases of Sullivan and Brown, JJ, and Nidlovu. I might be mispronouncing that. And we're also
as good as mine.
We'll also be hearing from Sara Little. She is an associate at Browdy Thorning LLP. Her practice focuses exclusively on criminal trials and appeals. Prior to joining the firm, Sara completed a judicial clerkship at the Court of Appeal for Ontario, where she clerked for some of the top criminal law jurists in the province. Sara also runs a legal blog, Little Legal Summaries, sponsored by Eamon Publishing, that aims at providing legal professionals with summaries of recent criminal appellate jurisprudence. And Sara will be speaking tonight about the cases of La France and Campbell. And we're very lucky to hear from all our speakers. And without further ado, I will pass the floor to Stephanie.
Thanks so much, Shira. Thanks to Jennifer, Shira, and Maya, and the whole WiCCD team for having me here tonight. I'm so excited to address women in criminal defense from across Canada and to talk about some really important cases along with my co-panelists. We don't have a lot of time, so I'll get started. Hold on, I'm going to start my timer here. Okay, so the first case I want to talk to you guys about is JJ, 2022 decision SCC 28. And this is a case that you're going to want to think about and review every time you're putting together your trial strategy to defend a sexual offense. It deals with the constitutionality and interpretation of section 278.92 of the Criminal Code, a section that was enacted within very recent history to the consternation of most defense lawyers. It's the section that requires us, before we can cross-examine or otherwise adduce into evidence a record, so like a text message or a medical record or a counseling record or several other types of records, to run that record by the trial judge. It engages issues of reverse disclosure and also creates a test for the admission of any type of record, or to just even adduce it in cross-examination. On the first point, constitutionality, spoiler alert, the section has been found constitutional by the Supreme Court of Canada. And regarding the interpretation of 278.92, the court talks in this case about first, what is a record? So record is a statutorily defined term, and it doesn't, and the court talks about that definition and what is a record that's captured by the legislation and what isn't. The Supreme Court also talks about the procedure for these types of applications. Like most of the statutory screening regimes that we see around sexual offenses, is a two-stage process with a stage 1 and a stage 2. And also talks about how we interpret the statutory test. Excuse me. So essentially, I'm going to focus on the test and talk about the procedure a little bit as well. What the Supreme Court tells us is that at stage 1, the court is supposed to look at the question of whether the record is capable of being admitted with reference to the factors in 278.92 sub 2. So that's the stage 2 inquiry. So at stage 1, what happens is that the judge examines the record and just decides whether it's conceivably possible that that record could be admitted in reference to the factor test outlined at stage 2. The legislation requires that defendants disclose detailed particulars of the evidence they want to adduce. And the court also tells us that the judge can govern this inquiry in line with their trial management powers. So for example, in Ontario, a practice has developed of sometimes filing that evidence under seal so that the trial judge can examine it without the Crown being able to see the evidence at stage 1. The Supreme Court also talks about stage 1 being able to proceed in writing. The focus in practice tends to be on statutory compliance with the requirements under stage 1, things like notice. The complainant does not have participatory rights at stage 1. Stage 2 is the question of whether the record should be admitted. And the judge is supposed to ask themselves whether the record has significant probative value that is not substantially outweighed by the danger of prejudice to the proper administration of justice. Section 278.92 sub 2 has a multi-factor list of things the judge must consider when doing that inquiry. Now, the term record is statutorily defined at section 278.1 of the Criminal Code, and it says that it's that the provision is engaged for any form of record that contains personal information for which there is a reasonable expectation of privacy. The Supreme Court tells us that that's a narrow definition, that we should be looking at information of an intimate or highly personal nature that is integral to the complainant's overall physical, psychological, and emotional well-being, and that we look at both the content of the message and the context. So things like how that record came into the possession of the accused. Was it posted on Instagram for anyone to see, or was it a private text message communication? That's what we mean by context, and both things are going to be relevant. I'm going to turn now to the Nidlovu decision. That's a 2022 decision of the Supreme Court, 2022 SCC 38. This is a case you need every time you are dealing again with a sexual offense, including at the stage that you are advising your client on whether or not to accept a plea deal, and in the post-trial sentencing phase when the issue of SOIRA is raised. This is the case about whether the mandatory SOIRA regime in the Criminal Code is constitutional or not. And in this case, the court found that that regime is not constitutional. A little bit of factual background. This case is particularly about the mandatory lifetime SOIRA order that comes when an individual is convicted of 2 sexual offenses. The accused in this case was convicted at one trial of 2 sexual assaults that occurred at a party when he was heavily intoxicated. And very importantly, the sentencing judge reviewed his background and expert evidence and came to the conclusion that he was unlikely to reoffend. Despite this finding, due to his convictions on 2 counts of sexual assault, he was subject pursuant to sections 490.012 sub 1 and 490.013 sub 2.1 of the Criminal Code to a mandatory lifetime registration in the sex offender registry. So the Sex Offender Registration Act, just to remind everybody, has 2 important prohibitions, the constitutionality of which were both being examined in this decision. First, there's the mandatory fact of being placed on SOIRA when convicted of a sexual offense. And second, there was the mandatory lifetime being placed on SOIRA when convicted of 2 sexual offenses. The court found that both were non-constitutional and that they violated Section 7 in 2 ways. First, the mandatory aspect of both sections, and then also the lifetime aspect of Section 2.1 was considered to be even more an aggravated breach, so to speak. SOIRA, there's some nice language here on how SOIRA engages liberty by circumscribing individuals' freedom moving forward from the point of registration. And in the end of the day, the non-compatibility with the principles of fundamental justice for both sections was based on an overbreadth analysis, because the section caught within its ambit individuals who had no or low likelihood to reoffend. Sorry, there's some background noise. I thought someone was talking to me for a second. Okay, the sections also failed the Section 1 analysis, and both of them failed at minimal impairment, as overbroad sections tend to do. If Parliament could come up with a scheme that doesn't capture individuals to whom the section really shouldn't apply, then it's not going to be minimally impairing. And that was the decision here. And so breaches are found, but the remedy for those breaches is important and something to pay attention to. So first, the mandatory provision for a single conviction of sexual assault is unconstitutional, and it was struck down. But that declaration of invalidity won't take effect for a year. So the date of the decision was on October 28th, 2022. And so Parliament has been given a year to put in place a new scheme for individuals to be placed on SOIRA after they're convicted of a sexual offense. That means that if you have a client who's convicted of a sexual offense now, and you think SOIRA really shouldn't apply to them because they have a low likelihood to reoffend, you have to make an application and seek a Section 24(1) remedy in relation to your client. For the mandatory lifetime SOIRA order that comes with a second conviction for a sexual offense, that was struck down effective on the date of the decision. And so that section has been struck down, period. You do not have to make an application for that section not to apply to your client. So the lifetime aspect for 2 offenses, gone. The mandatory aspect for 1 offense, 2 offense, whatever, that mandatory aspect is still there, and you have to apply for a constitutional remedy in the interim. Okay, the last sort of group of cases that I've been asked to talk about are the extreme intoxication triplet cases that came out in 2022 from the Supreme Court. So those are the cases of Brown, Sullivan, and Chan. Very briefly, Brown went into a state of self-induced automatism through ingesting psilocybin and assaulted his neighbor. Sullivan went into the same sort of state through overdosing on his prescription antidepressants, and he stabbed his mother. And Mr. Chan also ingested psilocybin, went into a state of toxic psychosis, killed his father, and stabbed his stepmother. These cases all end up going to the Supreme Court of Canada together. And in the Sullivan case, in all the cases, the issue of the defense of extreme intoxication akin to automatism was engaged. The Sullivan case also engaged an issue about stare decisis and what happens when a provision of the criminal code is struck down by a superior court or a Queen's Bench or Supreme Court judge, so at the trial level. Does that declaration of invalidity mean that the law is struck down and it applies to all other trial level cases? Or does that only happen once the case gets to the Supreme Court of Canada effectively, because the operation of that declaration of invalidity is governed by the normal rules of stare decisis, which tell us, as most of us know, that decisions of the same level of court are persuasive but not binding, decisions of a court of appeal are binding within the province, and decisions of the Supreme Court of Canada are binding throughout Canada. So that issue is raised in Sullivan. What the Supreme Court did was they dealt with the extreme intoxication issue in Brown and the stare decisis issue in Sullivan. So that's where you want to look, depending on which issue it is that you're interested in. The Brown decision focused on a section of the Criminal Code, section 33.1, which vitiated the defense of extreme intoxication akin to automatism. And the Supreme Court found that it breached Section 7 of the Charter by allowing a conviction without proof of mens rea or proof of voluntariness. It also violated Section 11D of the Charter, the presumption of innocence, in that it allowed for convictions without, where there's a reasonable doubt on mens rea. In terms of Section 7, the court was focused on really 3 main issues. So first was that the section allowed for a conviction even where the act wasn't voluntary because the person's in a state of automatism. The second was that the section substituted mens rea. So it basically said that having the mens rea to get really, really drunk is bad enough that that it should substitute or make out for the mens rea of committing an offense like manslaughter or aggravated assault or sexual assault, you could substitute one for the other. And the Supreme Court said, no, that's wrong. Those are not the same thing. And that will capture some innocent people within the section, which doesn't allow them from benefiting from a defense. And the last thing that it did, and these are all very interrelated, but the last thing it did was allowed for convictions without proof beyond a reasonable doubt that the individual had the necessary mens rea for the offense they were engaged in. And so you could have a reasonable doubt, or it could be clearly established that the person had no intent to inflict non-consensual touching on another person, and yet assault would be made out, and that was a significant constitutional violation. The court also affirmed the idea from Creighton that the minimum constitutional mens rea is objective foresight of bodily harm. And that was important as well, because the section took away the defense even when people got drunk, really, really drunk or high, in circumstances where they did not reasonably foresee that they may hurt another person as a result of their conduct. Section 33.1 also was not saved under the Oakes inquiry on the issue of not being minimally impairing, again, for a similar reason, because it caught people in there who did not have all those features that are really important for culpability. And there's some suggestion there that if you, I'm at the end of my time, but I'm almost done, that if Parliament was to create a section that did ask for reasonable foreseeability of bodily harm, which they have done subsequently, that the section might be constitutional. So we'll see how that plays out.
Thanks so much, Stephanie.
Yeah,
that was awesome.
Very
okay,
fast.
We're gonna save, and I should have said this at the beginning. We're hoping to leave 10-15 minutes at the end for questions. So if you want, you could put questions in the chat for now, and then we can come back to them when we're finished, all of the panelists. But now we're going to turn over to Sara.
Great. Thank you to Maya for inviting me to speak on this panel, despite feeling highly unqualified to do so. And thank you to all the amazing women that were involved in planning this. It was a really great group of people to work with. So the two cases that I'm going to be discussing today are the, I guess, King and Campbell, although Queen at the time, and also the King and La France from the Supreme Court. And so Campbell is a case coming out of the Court of Appeal for Ontario. The citation, although I believe you guys have it from the email circulated, is 2022 ONCA 666. And this is a case by Justice Trotter. And at the outset, I would kind of say that the importance of this case really is in reaffirming, at least in Ontario, that the Queen in America from the Supreme Court is the general rule when it comes to reasonable expectation of privacy in text messages, and Mills is really the exception. And I would go so far as to say that it's a narrow exception, which is good news for the defense. And so generally, I don't think facts are necessarily particularly important in summaries of appellate decisions, but I think in this case, the facts are in fact a little bit important. So I'll go over them quickly. Essentially, there's three kind of key players. There's Mr. Gammy, who is an individual who the police eventually take possession of his cell phone. There's Mr. Dew, who is an alleged drug dealer who lends his phone to the appellant, Mr. Campbell. And then there's Mr. Campbell, the appellant, who believed he was communicating with Gammy using Mr. Dew's phone. And so essentially what happens is that the police execute a warrant at Gammy's residence, and they end up in the course of that arrest seizing two phones. And one of the phones essentially lights up with messages on the screen from an individual named Dew, and the police come to believe that those text messages are referencing a drug transaction that's in the midst of happening. And they specifically believe that the coded language in the messages is referencing heroin laced with fentanyl. And so they view this kind of as a public safety issue. They want to avoid fentanyl going onto the streets. And so they, without acquiring judicial authorization, begin engaging in a conversation surreptitiously from Gammy's phone with this individual named Dew. Turns out they're not messaging Dew. The appellant, Mr. Campbell, actually has Dew's phone. And so they engage in a number of messages back and forth, and they essentially arrange for Dew to attend Gammy's residence. And lo and behold, the appellant shows up and they arrest him for possession for the purpose of trafficking and conspiracy to traffic and a variety of drug offenses. And so the question that kind of arose in this case focuses on Section 8 on Section 8. And the question was essentially whether or not the appellant had a reasonable expectation of privacy that was objectively reasonable in the circumstances. And again, I think really what should be taken away from this case is that America is the rule and Mills is the exception, which was the opposite of what the Crown tried to argue in this case. And so Justice Trotter concludes that the police should have obtained a warrant prior to engaging in this type of what he called deceptive practice. And so the court kind of starts by going through America, and there's some helpful language in paragraphs 37 onwards, where Justice Trotter says that, again, reaffirming what the majority in America said, that the text messages by their very nature are highly private, and they just inherently have the potential to reveal highly personal or biographical information. It's also worth noting that the court points out that the trial judge erred in concluding that the messages did not attract a reasonable expectation of privacy on the basis that they were mundane. In one sense, that's probably factually inaccurate, in the sense that messaging about drug trafficking factually can hardly be considered mundane, but more importantly, legally, it's inaccurate. And the court reminds us that Section 8 analyses have to be content neutral. And here the trial judge made a legal error by wandering into the content of the messages. So it was not the content that mattered, but rather the fact that they were engaging in this conversation. And again, the potential for that type of conversation to reveal highly intimate information is what triggered Section 8. There's also some important language at paragraph 45 onwards about control and how that factors into assessing whether or not an individual has a reasonable expectation of privacy. The trial judge and the Crown on appeal essentially tried to argue that because the appellant was using another person's phone, the owner of that phone could have easily accessed the messages, and that undermined the appellant's assertion that they had a reasonable expectation of privacy in the conversations. And the Court of Appeal is pretty quick and express in dismissing that notion and saying that control, again, reminding us from the language in America, is only one factor to consider. It's not dispositive in assessing whether or not someone has a reasonable expectation in privacy. And it also reminds us of the important distinction between state interference and interference by members of the general public. And so the fact that Dew, in theory, could have accessed those messages at some point is much different qualitatively than accepting the risk of state interference into those messages. And so the fact that Dew potentially could have accessed those messages didn't undermine the appellant's reasonable expectation of privacy from state intrusion upon those messages. And then the court has some helpful language considering Mills. And just as kind of a quick reminder overview, Mills is the internet luring case where messages between an accused person and who they believed was a child, but was in fact an undercover officer. The Supreme Court concluded that there was no reasonable expectation of privacy in those messages. And there's kind of two sets of reasons that make up the majority in that case, one by Justice Brown and one by Justice Karakatsanis. But in essence, they both say somewhat the same thing, which is that in that specific scenario in Mills, there was no reasonable expectation of privacy in the text messages between the accused and who ended up being the undercover officer, mainly because of the relationship between the parties. Because the individual that the accused was messaging was a stranger to them, and on top of that was a child. And kind of secondary to that was kind of the context or the technique used by the police, namely that they had created a fictitious person, so they were aware of the relationship between the accused and the individual at the outset of them entering into that conversation. Because they created a fictitious child, there was no risk that the police were intruding on an authentic police conversation. And Justice Karakatsanis' sets of reasons kind of echo that, but essentially takes a broader view of that, in that situation, there was no reasonable expectation of privacy because the police were engaged in an undercover operation or a sting operation. And so that's kind of a quick overview of America and Mills, but what you need to know, or what's so important about Campbell, is essentially that when it comes to the reasonable expectation of privacy in text messages, Mills created a very narrow exception or exemption to America. And so America is kind of the leading or guiding proposition or set of reasons on that. And the Mills exception is seemingly so narrow that it seemingly only applies to participants in a conversation that are strangers to one another, and where the police know the relationship at the outset, in other words, before they intrude into the conversation. And this is really important because it again reaffirms that Section 8 jurisprudence is content neutral, but it is context specific. And so Mills seemingly only applies to the messages that create a crime against the recipient, such as child luring, but not to crimes in general, such as firearms or drugs, which it was drugs in the case of Campbell and firearms in the case of America. I would also encourage everyone to check out the Queen and Mootoo, MOOTOO, citation 2022 ONSC 367, which is a decision by former female defense counsel Justice Breeze Davies, and Justice Trotter relies heavily on her decision in reaching the conclusion that he does in Campbell, and it has a lot of helpful language as well. So the kind of ratio from this case, if you want to call it that, is essentially that there is a reasonable expectation of privacy where police impersonate a drug dealer using a seized phone to continue a pre-existing private text conversation. That duped person has a reasonable expectation of privacy in that conversation. Ultimately, however, in this specific case, despite finding that there was a reasonable expectation of privacy, Justice Trotter concluded that there was no Section 8 breach, given that there were exigent circumstances that justified the Crown behavior. And so I'll turn then to the Queen and LaFrance, and the citation for that is 2022 SEC 32. And I would say this case is helpful to the defense toolkit, if I can call it that, in two main regards. The first is in relation to Section 9 detention jurisprudence, and the second is in relation to Section 10B right to counsel, particularly the implementation component of right to counsel. And so, again, just by a brief overview of the facts, the police had suspected that Mr. LaFrance was involved in the death of an individual. Notably, Mr. LaFrance was 19 years old, he was Indigenous, and he had very limited interaction in the past with the criminal justice system or with police. The police attended his home to execute a warrant in the middle of the night. There was some pretty egregious police conduct involved, and they took him to the station and interviewed him for 3.5 hours without giving him right to counsel, without arresting him. They released him. A few weeks later, they arrest him. This time they arrest him for murder. They now give him his right to counsel, and they begin interviewing him rather. And I'll get to that part a little bit later. But At trial, defense counsel sought to exclude, he essentially in his police interview following his arrest, confesses to the murder. And so defense counsel sought to exclude those confessions on the basis that he had been detained the night of the warrant, which was 2 weeks prior to his arrest. And the trial judge essentially found that Mr. LaFrance had not been detained, which is a little difficult to believe, but that was appealed to the Alberta Court of Appeal, who allowed the appeal and ordered a new trial. And then that was appealed to the Supreme Court of Canada with a 5-4 split, favoring the defense, so dismissing the Crown appeal. And so I would say that LaFrance is the latest case that defense counsel should have in their Section 9 toolkit, along with the Queen and Grant 2009 SEC 34, and more recently the Queen and Lee 2019 SEC 34. And in LaFrance, the Supreme Court essentially reiterates that the proper test or the proper factors to consider in determining whether or not an individual has been detained prior to arrest is outlined in Grant and Lee. And so that test, by way of overview, is essentially it's an objective inquiry, and it takes into account the perspective of a reasonable person in the accused's shoes. And that requires the court to consider 3 factors. First, the circumstances of the encounter, how the circumstances of the encounter would be reasonably perceived by an individual. Second, the nature of the police conduct, including their actions, their language, the duration of the encounter, etc. And lastly, the circumstances of the individual, including but not limited to the age, physical stature, minority status, level of sophistication, etc. And so the Section 9 portion of LaFrance really focuses on the third component, which is the individual circumstances of an accused in assessing whether or not they've been detained. And as I mentioned earlier, notably, Mr. LaFrance was an Indigenous individual. And so there's some helpful language at paragraphs 55 through 59 in describing how an individual's indigeneity or racial status becomes relevant in assessing whether or not an individual has been detained. And of course, there's helpful language in Lee as well in the context of a Black accused, and the court essentially expands on that in LaFrance in the context of an Indigenous accused. And so the court essentially, the short and long of it is that a court in assessing whether or not an individual has been detained must take into account 2 things. First, the relational aspect between police and Indigenous persons. In other words, the overwhelming power imbalance that results between any detainee and police, but how that power imbalance is heightened in the context of an Indigenous accused. And 2, the resulting possibility that their interactions, that an Indigenous accused interaction with police would reasonably be perceived by an Indigenous person as depriving them of the choice to cooperate. So I would strongly encourage everyone to read paragraphs 55 through 59. There's some really helpful language there if you have a client who's an Indigenous accused and you think there's some Section 9 issues that arise in the context of their case. The second aspect of LaFrance that's really helpful for the defense is the language surrounding 10B or the right to counsel, specifically the implementation component of the right to counsel. And that begins at paragraph 72 onwards. And so there's some really helpful language in LaFrance about how the right to counsel is not just about receiving advice, but also, more importantly, an accused's ability or a detainee's ability to understand that advice. And so there's kind of an overview of 10B jurisprudence, but the court says, the duty to hold off questioning until a detainee consults counsel is part of 10B. But beyond that, police have a duty to provide a secondary caution or a secondary opportunity to consult counsel in a variety of circumstances, but particularly one circumstances that triggers that duty is where there's reason to question a detainee's ability to understand the advice that they've previously received. So an individual might understand that they have the right to silence, but more importantly, they need to understand how to exercise that right in the face of police interrogation. And so there's some helpful language surrounding this that is, one, helpful in bringing 10B challenges, but also can help us inform how we provide advice to our clients when we get calls that they've been arrested or detained. And that includes that advice should include not only the fact that they have the right to silence, but how they can go about exercising that. And so that would include the benefits and drawbacks of cooperating with police and potential strategies to resist cooperation in the face of a particularly intense police interrogation or interview. And that legal advice similarly has to be tailored to the particular circumstances or situation that the individual is facing, and conveyed specifically in a manner that the individual would be able to understand. And the majority, and again, this was a 5-4 split. My comments today will focus largely on the majority, given that's the state of the law, but a big main point of contention between the majority and the dissent was the fact that 10B as a whole is intended to redress a power imbalance between detainees and the state, or detainees and the police. And the majority's view that the only way for Section 10B to meaningfully combat this power imbalance was to ensure that accused individuals or detainees are aware of how to implement or how to effectively resist cooperation when that's in their best interest. And the degree of power imbalance specifically can be impacted again by racial or indigenous status, or the particular vulnerabilities of a given detainee or accused, including racial status or indigeneity. And so in this specific case of Mr. LaFrance, following his arrest for murder, he was given his right to counsel. The informational component was there. Initially, the implementational component was there. He was given a call to legal aid. He was then brought into an interview room, and during the midst of his interview, he asked to speak to his father because he viewed that as the only way for him to get a lawyer. And he kind of shed some light in some kind of utterances as to the type of advice that he got, or the way he at the very least understood the advice that he received. And so it was clear from those utterances that either he received bad advice or that he simply didn't understand the advice that he received. And the majority noted that this was also heightened by the fact that he was quite young, the fact that he was Indigenous, and the fact that he had very little experience with police or the court system. And so as a result, given that it was clear to the police during the course of the interview that he either misunderstood the advice he received or he received bad advice, the police had a duty in that circumstance to provide him with a second opportunity to consult counsel, and the failure to do so amounted to a Section 10 breach. And that's LaFrance.
Okay, I guess that makes it my turn. All right, so I'm going to talk about two cases here. The first case that I'm going to talk about is the major decision, which is a major decision from the Saskatchewan Court of Appeal. And this case involves a search of a vehicle. So the facts don't really matter in the case. Essentially, there was an accident, there was a death, several deaths actually. It was really tragic. The vehicle rolled on its side, and the police seized the airbag control module from inside the vehicle. And then inside the airbag control module, there's a little data recorder called an event data recorder. Sometimes they call it an event data monitor, EDM or EDR, you would see in the case law. And they took the data off of that, and that data allowed them to determine sort of what the speed of the vehicle was in the seconds leading up to the collision, when the brakes were applied, if there was any sort of record of any evasive action taken to avoid a collision. And it was relied on by the Crown in the trial for the purposes of proving the dangerous driving causing death offense, and specifically the driving evidence. So at trial, there was a challenge to whether or not the data was actually admissible without a warrant. And then there was also a second question of whether or not the data could actually be relied upon under hearsay exceptions. And this case is super important because there was conflicting case law from various courts across the country dealing with the question of whether or not a warrant is actually required to get the event data recorder data, or whether there isn't an expectation of privacy in it, and therefore the police can just go and take it. And so the court does a really good analysis in that case about whether or not there is an expectation of privacy. So the citation for the case, just so as everybody has it, is 2022 SKCA 80. Major is the name, so it's easy to remember because when you're looking at event data recording data, you will have a major headache because it's really boring to look at. So they talk about the charter challenge beginning at around paragraph 35, and the court sort of discusses the competing lines of authority, ultimately agreeing with a Court of Appeal decision that came out of BC called Fidan, where the BC Court of Appeal had said there's no objectively reasonable expectation of privacy in this event data recording data. Although there's certainly a subjective expectation of privacy, it's not objectively reasonable for a number of reasons. And the court in Saskatchewan adopts this and essentially endorses Fidan. So now there's like 2 Court of Appeal decisions that say the same thing. So unless it goes to the Supreme Court of Canada, which I don't think it's going to, this will probably be the prevailing law. But all is not lost. Don't worry, there is a silver lining here. So at paragraph 56, the court kind of settles on this notion that, yes, there's a subjectively reasonable expectation of privacy. And I thought really cool about that case was that Major never testified about any expectation of privacy. It was just sort of like accepted, and the court endorses that approach. So it's a good case for the proposition that you don't have to testify in order for the subjective expectation of privacy to be made out generally. And then they look at whether the expectation of privacy was objectively reasonable in the data. And there were a number of things. Mr. Major relied heavily on the fact that he had sort of like a territorial privacy interest. It was his vehicle. In other cases where there was not found to be an expectation of privacy, they were rental vehicles, which had rental agreements that said that the data could be turned over to the rental car company or to the lease holder, the lessor, if it was a leased car. But here it was his car, he owned it. So he had this, sort of this interest in the privacy of it. But the court found that sort of the territorial privacy interest in the vehicle kind of ceased to exist when the vehicle rolled on its side and then was seized by police just generally as part of the investigation. And it wasn't drivable at that point. So that portion of the privacy interest was no longer reasonable. And then as far as the informational privacy was concerned in the actual contents of the data, there was nothing that really went to like the biographical core of Mr. Major or any sort of private information. All the information revealed was stuff that would have been observable by anybody standing on the street witnessing the accident happen. How fast the vehicle was going, whether the brakes were applied, whether he tried to steer out of the way to avoid the collision. That type of information is not something in which you have an objectively reasonable expectation of privacy, because the manner of operation of a vehicle doesn't attract a privacy interest. I mean, I guess there would be some circumstances in which it could, like if you were operating your vehicle in like a closed track that you owned, but this was a public roadway. And of course, as we all know, all the time on vehicles on public roadways, you have a diminished expectation of privacy to begin with. And the court, of course, brings that up. Like you're already starting from a lower level of privacy, and then you're talking about just the manner of operation of the vehicle. And that's described at paragraph 69, where the court says the closest an EDR comes to saving any personal information is its storage of the manner in which the vehicle was driven immediately pre-collision. And even that, it said, was just a brief snapshot of the status of various mechanical and electrical components of the vehicle. So it's also like the data that you get, because it's like a plane's event data recorder, right? You're getting a couple seconds of data. You're not getting the entire time the vehicle was driven. So you don't even get that much information. Like you're getting, 5 seconds before the collision, which is just like, it's nothing in the context of attracting any privacy interest. So the court concludes that Mr. Major did not have a reasonable expectation of privacy. Now, I'm sure that Mr. Major hearing that and getting the decision is thinking, not going my way, but this is the silver lining. And it was the question of then what happens to this data? Once the Crown has it, and once it's, there's no Section 8 consideration that applies in relation to it, can the court just receive evidence about what was on the data or receive a police officer's explanation of what the data meant? And the court says no. And this is the best part of the decision, because a lot of Crowns don't know about this decision yet. So don't bring it up until you're like in the trial, please. Because they don't know that essentially as a result of this decision, they have to get an expert from Bosch, who manufactures this part of the car, and it's Bosch in every car. They have to get an expert from Bosch to actually come and authenticate the data in the document and establish the reliability of the data that comes from the EDR, because otherwise it's just sort of numbers and the court has no way of knowing the reliability of it. The police don't look at the reliability of the data. So that discussion begins at paragraph 80. The Crown tried to rely on the Canada Evidence Act exceptions to allow the electronic evidence to be put into court. And the court says at paragraph 80, first, obviously, you have to prove authenticity and the integrity of an electronic document can be established by establishing the integrity or reliability of the electronic document system in which it is recorded or stored. So in order for the document to be found to have the necessary integrity to be admissible pursuant to a hearsay exception, it actually has to be have evidence from Bosch to say this is a reliable way of recording this information. That is an issue. Now, they did have an officer testify as an expert to try and overcome this, but the court found at paragraph 87 that even with Corporal Green's evidence, it still didn't provide a sufficient basis for admissibility. Even when you combined the Canada Evidence Act and the evidence of the officer, that threshold was still not met. And then the court looks into the threshold reliability of that evidence and found that essentially, again, without the proper evidentiary foundation, it was not possible for threshold reliability to be made out. So it's a super important case for that reason. Couple really good paragraphs on that, 101 to 103, where the court essentially says that maybe in the future, this is going to be as commonplace as like a photocopier or a fax machine, or other things that we lawyers like to use from the Stone Ages. And it might become so commonplace that we don't need expert evidence to testify about this. But right now, that is not the case. Just because data has been recorded in the EDR and extracted by software doesn't mean that it's reliable. And so there has to be a properly qualified expert to explain how the system accurately records the data, creates an accurate output. Otherwise, it does not meet the threshold required for admission. And the police experts are not qualified in well, at least they aren't yet. They're probably going to get training on it, I would expect. But at this time, none of the ones that I've ever dealt with have been qualified in any of the areas related to that. So the court determines that the technology has not progressed to the point where it falls into the same category as a speedometer, video recorder, wristwatch, spreadsheet program, or similar item of everyday use. And unless an accused consents, then the threshold reliability has to be proven by the Crown, or else then you are stuck without it. So really good case, super helpful, especially if you are dealing with that, okay, I'm going to run out of time here because I'm running over and I've got 2 minutes to go through Boyle. So I had questions that I'd written, but I'm going to skip over them. Boyle is an Ontario Court of Appeal decision 2022 ONCA 611. And this case is really straightforward, so I don't actually need a lot of time to explain it to you. Mr. Boyle was charged with criminal negligence causing death. And so in the spectrum of sort of driving offenses related to death, criminal negligence is not specifically a driving offense, but you see it a lot of times where there's like really bad driving, like it's worse than dangerous driving causing death. But when the criminal code was amended in December 2018 under Bill C-46, they changed the sentencing provisions under the offenses relating to conveyances. So it used to be under the old 249 that you could get or 259 that you could get the driving prohibition for a criminal negligence causing death offense, as well as for dangerous driving causing death and all of the other ones. But when they amended the code, they removed the reference to that, and they only included references to the actual conveyancing offenses in the 320s. So the question was, can a driving prohibition be imposed for criminal negligence causing death? And the Crown got super creative in this case. And they were like, well, it says if you're found guilty of the offense of dangerous driving, and because criminal negligence causing death is like a higher offense, then by necessary implication, you're also guilty of the lower offense. So you should still be able to get the sentence that you would have got then. And the judge was like, yeah, I mean, we agree that this is kind of absurd, that you get a lesser sentence effectively if you're convicted of criminal negligence causing death, as far as there's no ability to impose a driving prohibition, but that's what Parliament wrote. And as creative as your argument is, it basically manipulates criminal law in a way that's never been done before to try and punish people for an offense for which they have not been charged or convicted, even though it's a lesser included. And that would also problematically, fly in the face of the pineapple principle, where if they were charged with both, they could only be convicted of one. So that's a problem too. So no, even though you're very creative, Crown, you're creative in a kind of evil way, and we don't like it. And so it's not going to persuade us. Then the court looks at whether or not it's possible to fix this as like a legislative error, because it couldn't be possible that the Parliament actually intended that there be no driving prohibition if you kill somebody through negligent driving. Like, how does that make any sense? And so the court was like, well, judicial action can be taken to fix legislative errors where they're minor. But this is not minor. This is really significant. It goes directly to the heart of the sentence that somebody's getting. And to just judicially impose a driving prohibition that isn't in the criminal code would create chaos. So Parliament has to fix this, and hopefully they do it quickly, because otherwise it's kind of a problem. But also, like Crown, just charge dangerous causing death, because if you can prove the crim neg, you can prove the dangerous, and then you can have your driving prohibition. Now, I would say one thing with respect to this, and I'm talking fast because I'm going to run out of time, which is I would be careful, because I don't think that the Crown is really that stymied in this, even if they wanted criminal negligence, because you can also just ask for a probation order, and you can ask for, as a condition of the probation order, no driving or not to be in the driver's seat of a motor vehicle. And we see that with lots of other driving offenses where there are no mandatory prohibitions, like a dangerous driving, and that can attract that type of a probation order. So I think they can get around it that way too. But at the very least, if you have someone charged with criminal negligence causing death who would love to go to jail but not lose their license, I guess plead them guilty. This is terrible criminal law advice, but there you go.
Thank you, Kyla. I will ask you some questions at the end. So now over to Christa.
Hi, everybody. I'm in Nova Scotia, so it's almost my bedtime. I'm not sure if everybody else is from a different part of the country, and maybe you're just eating your supper or whatever. But if I look a little tired or sound a little slow and confused, that's why. It's been a long day. I am speaking about cases that are very near and dear to me. Anderson from the Nova Scotia Court of Appeal, Morris from the Ontario Court of Appeal, and King, which is from the Ontario Court of Appeal. Morris and Anderson are representative of a move towards accounting for racism against Black Canadians that is perpetrated by our justice system. King looks at the relevance and use of Gladue principles in the context of a court application. So I'm going to start by speaking about Anderson. I'm very proud to be from Nova Scotia and be talking about Anderson. It's a really exciting case for anybody who is excited about cultural competence. I'm also very privileged to have had an opportunity to have worked with some of the people who are involved in this case, and I know the players and I really respect them, and I know how much work went into this case. Anderson is probably the most significant case in Nova Scotia to combat systemic discrimination against African Nova Scotians. It's a sentencing decision. It had to do with gun offenses. Just briefly for the facts, because I do think it's important to understand Anderson's situation. Anderson was subject to a traffic stop and a firearm was found, but there was no other sort of criminal activity that led to the discovery of that firearm. That said, the counsel who assisted Anderson at the early stages wasn't successful with their arguments, and eventually we got to a point where Anderson was going to be sentenced. The key point from Anderson to keep in mind when I talk about it is that IRCA's impact of race and culture assessments, something that has been cultivated in Nova Scotia to assist in the sentencing of African Nova Scotians, they have been determined that should be required each and every time an African Nova Scotian person is being sentenced in our courts. And what the IRCA allows the judge to do is take into account the extent to which systemic discrimination, both immediate and historic, have shaped the person and how it has the potential to affect their experience should they go to jail. One important thing to note as well, in terms of talking about Anderson, is that in Nova Scotia, we refer to African Nova Scotians, and we do refer to that group as a unique group because African Nova Scotians have a unique history in Nova Scotia. And when you read the cases that are Anderson and X case or Kale Gabriel, you can see some of that discussion and it becomes apparent to you, but just where this is outside of Nova Scotia, I wanted to flag that. So what is an IRCA? I'm not sure how common it is really to talk about IRCAs outside of my province and outside of Ontario. That's where I'm used to hearing and learning about it. But an IRCA is an impact of race and culture assessment. Essentially, it's a report. I would say it's akin to a Gladue report, but obviously there's distinctions between Indigenous people and African Canadians. But that idea of having something before the court that educates the court on the systemic background issues and factors that have contributed to bringing the person before the court was the concept. I had the privilege of being the lawyer in the first case where IRCAs were put forward. And so when you read Anderson and you see Robert Wright, who's the expert, he is actually the expert that I had worked with when I did the X case. And he is the pioneer for IRCAs. He made them up. He basically, through his own expertise, was able to design a template for a report and put that forward. So IRCAs are meant to be used as a tool for the court to assist in sentencing and understanding the personal circumstances of an offender who is African Nova Scotian or African Canadian, depending on where they're located. The tool is meant to provide a cultural lens through which to view the individual circumstances and their background factors, and to determine how those things have contributed to bringing the person before the court. And I think it's important to note, we're all lawyers, we're all well aware that there are inequalities that exist in the Canadian criminal justice system that disproportionately affect Black Canadians. And there are also inequalities, obviously, in Canada that disproportionately affect Indigenous Canadians. The IRCA is meant to even the playing field. And one thing I like to clarify when I talk about IRCAs is, and maybe this is because I'm sensitive, because I was around at the beginning and I got a lot of critique that I didn't think was fair, but when you're putting an IRCA before the court, you're not arguing that race is mitigating or that somebody should have a sentencing discount because of their race. What we're doing is we're acknowledging that the criminal justice system has been stacked against Indigenous people and African Canadian people. They're coming into a system where they don't have the same level of equality or fairness than other people. And so the IRCA is meant to even the playing field. It's not an advantage over other people. It's recognizing that these populations, like with the Gladio report, are disadvantaged and that this information is required to lift them up and equalize the playing field. And I feel very strongly about that because when I was first involved in these types of cases, people said a lot of things to me that I found were downright insulting because it's not a mitigating factor. It's recognizing the disadvantage that is built into the system and is systemic. Another thing I wanted to highlight, I know everybody can read the case. It's kind of a long case. One good thing about Justice Derrick is she's a great writer, so it's actually pretty interesting to read. But with both Gladio reports and the IRCA, they're both aimed at that idea of wanting to tackle injustice to these historically disadvantaged communities. But I do think it's important to note, and I would note on paragraph 92 of Anderson, that the courts and in Morris as well have acknowledged there's obviously a unique history to Indigenous people in Canada. Indigenous people in Canada hold a unique place in our Constitution and our legal framework. And so the Gladio report and the regime that's meant to assist in those cases is clearly distinct. But one thing that the Indigenous clients and the African Canadian clients who what they have in common coming before the system is this overrepresentation in jails and just being discriminated against for reasons that are beyond their control. And the barriers they face are systemic and institutionalized. So let me just look at the time because I get excited and I might have lost track of it. All right. With Anderson, this is not a conventional appeal. I remember hearing about Anderson and being up in arms at the thought of the Crown appealing. But in this case, the Crown has actually taken it upon themselves to endorse the view of the trial judge or sentencing judge, but they've sought out, and then the interveners have joined in as well, and sought out and asked for essentially directions and guidance in applying these sentencing principles in our province. IRCAs have been around in Nova Scotia since 2014. And so they basically, they've evolved over a number of years, but this was an opportunity for our highest court to weigh in. One thing I want to flag as well is we know that there is a clear connection between using CSOs and conditional sentence orders as a response to the over-incarceration of people generally. In Anderson, it's interesting because the CSO is used and discussed in the context of an African Nova Scotian, but again, it's a tool to be used to try to counter the over incarceration of these marginalized populations. So what I would say to summarize Anderson is that the case is excellent. It provides an evolution of IRCAs. The author, Justice Derrick, was actually, when she was a lawyer, was involved in the Donald Marshall inquiry, which was, I'm not sure if people outside of Nova Scotia are aware, but that inquiry had to do with discrimination against Black and Indigenous people in Nova Scotia a couple decades ago. And we're still talking about it, and we're still trying to work with its recommendations. So Justice Derrick she has been involved in these ideas since she was a lawyer. She was the trial judge when I put the X case forward to her, and she accepted cultural impact assessments. And now she has since been appointed to the Nova Scotia Court of Appeal, and she's authored Anderson, and I love it. I'm really excited about Anderson. The bottom line is that in Nova Scotia, when you're assisting an African Nova Scotian person with their sentencing, you're supposed to ask for an IRCA. A judge is supposed to contemplate the type of information that would be in an IRCA. If you don't ask for it, then be prepared to, the same way you would if you don't ask for a Gladdy report, give the court the information that they need to understand the basics of the person's experience, because in Nova Scotia, the court's required to include this analysis in their reasons. So I love Anderson. I'm very excited. I'm going to also now switch gears to Morris. I might sound a little more tongue-tied when I talk about Morris because it's in Ontario, not Nova Scotia. They use different language, but Morris is again, these cases make my heart warm. These are why I went to law school. I get excited about this stuff. This case makes powerful proclamations on anti-Black racism in this country. And I love it. You know, it's written right there in the decision. It is beyond a doubt that anti-Black racism continues to be a reality in Canadian society, and in particular, the Greater Toronto area. That acknowledgement from a court of appeal to me is just so powerful compared to when I first started, you know, wondering about these things and not necessarily seeing them. In Morris, similar facts to Anderson in that it's the weapons case, youthful offender. He was African Canadian, and his counsel introduced what they called social context evidence through the form of 2 reports. Those 2 reports, when I read their description, sound an awful lot like an IRCA. Basically, one report was the more general description of research-based information on the causes, impact, and existence of anti-Black racism in Canada, and specifically to the community where this case was. The second report was a social history unique to Mr. Morris. And so with the social context evidence, in that case, the Court of Appeal in Ontario found that that evidence provided the trial judge with a basis upon which to assign more weight to rehabilitation. I have a lot to say. I already feel like I'm running out of time. So I want to focus on just one little point in Morris that I really like, which is the discussion on proportionality. There's discussion about what role does social context evidence play in this analysis, and they rejected the idea that it would be considered in the gravity of the offense. But that said, when we look at proportionality and the degree of the responsibility of the offender, that the court has accepted in terms of assessing the individual responsibility of the offender, that social context evidence matters. And social context evidence, social context evidence takes the form of evidence related to individual characteristics like the background, mental health, family, education, etc. But also, like the IRCA, touches on the macro inequalities, which would include the systemic discriminations. So I'm excited again to read Morris and Anderson hand in hand. And my timer just went off, which let me know that I've run out of time without touching on King. So I'm going to talk for an extra 2 minutes because I think it's important to turn to King. But I will say, if you're representing anyone with an African Canadian background, pull out Morris and Anderson. And for those of you who aren't in Ontario and Nova Scotia, set your precedents and name your reports and get going with them, because I think that it's a real movement that's happening. I'm really excited that my province has been so active in it. Okay, so King, 2022 Ontario Court of Appeal. This case has to do with self-defense. And it also has to do with corporate applications and a ruling on disreputable conduct. I don't have much to say, much time to say everything I want to say. So I'm going to gloss over the self-defense stuff and say, if you have a self-defense case, read it, because I think you'll be interested in what it has to say. But sticking with my theme of cultural competence, this is just another example of how Gladio principles are being welcomed into different areas. Gladio reports are not meant to be limited to sentencings, and they can apply in different contexts like bail, at review board hearings. There's all sorts of scenarios. Well, King gives us the direction and a bit of a roadmap about how to make use of Gladio principles in the context of Corbett application. Now, I'm assuming people would know what a Corbett application is, but just to recap, when you're dealing with a jury as a trier of the fact, when the Crown closes their case, if the accused is taking the stand and if the accused has a record, you're going to want to do an application to determine if the offenses that are listed on that record should be put to the accused, or if their probative value is outweighed by their prejudicial effect. And as we know, when an accused is being, cross-examined on their record, we want to avoid propensity reasoning. And so I run out of time, so I can't really go into it, but I just want to say that there's an acknowledgement in King that the discrimination that is faced by Indigenous people can be compounded in situations where their record is put to them. And there's a risk of prejudicial stereotypes. So I'm going to end there because I don't want to take up all the time. But if you have a jury trial, please read King if you're dealing with an Indigenous client. And I'll stop.
Thank you so much. We have about 5-10 minutes for questions. So either people can put their questions in the chat. There was one question earlier. This was perhaps directed to Sara. This was in the chat from Kyla. Is it not incongruous somewhat that there is no expectation of privacy based on the fact that the receiver of a text message is not a real person when the sender clearly did not believe that?
Yeah, I think that's an interesting comment. I'm not sure I have the answer to it, but I would say that the court generally was trying to focus more so on whether or not the sender and recipient were known to one another. So the relationship in that sense. So in Mills, it being a complete stranger, whether fictitious or not, an individual hardly has a reasonable expectation of privacy in communicating with a child that's unknown to them, versus in America, in Campbell, in Mutu, the relationship between the parties is that of acquaintances, business partners, colleagues, friends, however you want to characterize firearm or drug dealer relationships. And so, again, the nature of the relationship, the fact of whether or not the recipient and sender are known to one another, rather than whether or not they are fictitious or not. But I still think it's an interesting point.
So can I follow up with a second question on that? Am I okay to just jump in? Then, like, could that then by extension apply to any sort of like really early communications when you're just getting to know someone, like your Tinder messages, when you match with someone and things like that?
Again, I'm not sure I'm going to solve Section 8 jurisprudence in this panel. If any of the other panelists have thoughts or answers to that, feel free to jump in. I think it's hard to say without any further information because it is so context specific. It's not necessarily dispositive in terms of the nature of the relationship or how long they've known each other, but yeah, I think you need more information. It wouldn't be like a bright line rule. I think you need more information to assess the context in which the communications are happening, and more specifically, the context in which the police are somehow injecting themselves into this conversation.
I just turned on my my mic to say it's interesting too that the court it's a very small part of the decision, but seems to say almost the opposite in Ramilson, which also came out this year.
I have a question for Kyla, if nobody else has a question. Just asking about major and just in terms of helping out defense counsel, do you see, or what kind of workarounds do you see the Crowns might be using to get this EDR data over the threshold reliability hurdle in future?
I mean, I think one of the things I kind of alluded to this when I was talking about it is I think they're going to go take their police experts and they're going to send them off to Bosch to be trained so that they can talk about it. Like we've seen them do that with other things in the driving context, especially where they've sent them, you know, they send them for the DRE training in Florida for several weeks. I'd like to go to Florida for several weeks to learn something like that. You know, they send them off to intoximeters to take courses. And I think they're just going to spend the money to train up some of their sort of, well, I don't know what you guys have in your other provinces, but in BC we have ICARS, which is like an integrated collision investigation unit. And I think that they would just send all of those members off to get that training. So then they can come to court and be like, I'm an expert in this and I got trained. Gosh.
That's really annoying. Do you see any circumstances or cases where defense counsel might want to actually consent to the EDR data?
I have one right now, and it's actually the EDR data is in the victim vehicle.
Oh, I see.
Yes, and it shows that that vehicle was traveling well in excess of the speed limit. So as far as like causation on the injuries in that case, I think that that's a case where I'm going to consent to it going in because it helps my client. So that's one big one is, you know, on EDR data from victim vehicles, but also lots of times the data is actually helpful to your client. It might show that they applied the brakes. It might show that they took evasive maneuvers. And so you would want to get that in. And the Crown usually doesn't care too much about keeping it out if it's helpful, because it's problematic if they do. And you're going to get it in yourself anyway. So
Interesting. Thanks, Kyla. I think Anita has issued a directive to everyone to put their cameras on.
Everyone but Anita. Sorry, way past my bedtime. But first, actually, I'm asking everyone to turn your cameras off, forgive me, other than the panelists. So I can just get a smiling appellate photo here of our wonderful panelists. So 1, 2, 3, wicked women.
Good women.
Okay, beautiful. I'll take one more just to be safe. This is, by the way, my job. I'm the exec. I'm the free photographer. Okay, 1, 2, 3, smile for me. Beautiful. Okay, perfect. And now I'm going to ask everyone, please, who, thank you, Tanya. You're so good at this. Tanya's always got her camera on for us. And there's Hamna. There's everybody. So everyone who feels comfortable, please turn on your camera for me. And people are still popping on. This is wonderful. Okay, I'm going to take the first screenshot. I'm going to count to 3 and you can say whatever you want, but you know what I want you to say. 1, 2, 3, wicked women. Very nice. And let me just take a second screen. This is the part where everybody who's not on the screen smiles anyway, because nobody knows what I can see. That's my favorite part. 1, 2, 3. Okay, perfect. Thank you so much. That part is done. And then you've got a book to give away, and the 4 people who just left are the biggest losers. They'll never know. So who's giving away the book?
All right. So the winner is Alisa Khan Parikh. Not sure how. I hope I
She's
pronounced
still
it.
here. She used to work for me, and that is not why she wins this. It's just like Alisa, wave.
I'm here
She's still here to the bitter end. That's a great
with
great
2
book
babies.
for
I'm still here.
2 brand new babies. Fantastic. It's a great book. Congratulations. That was really nice of Dana and Haas and Eamon to do that for us. It's a wonderful book
Thank
for
you.
Dana. 2 women co-authors. That's why we picked it. Enjoy. Thank you everyone for a wonderful session. I'm going to shut up now. Once I start, I can't stop.
So before we wrap up, I just want to thank all the panelists tonight. I think we all learned a lot, and this is really what WiCCD is about. It's about women supporting women in Canadian criminal defense. And that came through tonight with having women from coast to coast presenting on cases from coast to coast. And this was an excellent event. I think that we all have more cases to include in our toolkit, from charter cases to cultural competence cases to impaired and driving type cases to SWARA, and in the rare cases where we are able to do the defense automatism. So we've all learned quite a bit tonight, and I want to thank everyone for being here, and especially big thank you to our panelists who spent so much time preparing for tonight and providing us with so much useful information. So big round of applause.
Thank you very much, you guys. It was really great.
Okay, I have to go post to Twitter, everyone. Thank you for everything. That was really fun. You made some of the boring stuff sound interesting. Is this still recording?
Yes, it is.
I think it is.
Everyone, thanks again.
Bye.
Good night.
Bye. Thanks.
Thank
Let's stop the
you.
recording.
Thanks, everyone.